Hello and welcome to my program, The Legal Messages. In this episode today, I shall be dealing with you. I shall be discussing with you another very important topic of Indian Evidence Act 1872. This topic is about opinion of experts. See, the court in various situations find it difficult to make its opinion on its own on issues on which it feels it is not an expert. In situations like such, the court has to ask for opinion from experts. It has to rely upon the experience, qualification, skills of the experts to form its own opinion. We'll see this has been dealt in section 45 of the Indian Evidence Act. This section says that when the court has to form an opinion upon a point of foreign law, science, arts, handwriting, and finger impressions, it has to seek the opinion of the expert and which is held as relevant. So, the court in such situation says that it will rely or it will take the help of the experts. But the question arises, who are the experts? It has not been very clearly defined in the Act who are the experts. However, we come to know about this thing through various judgments of the Supreme Court on various issues, on various types of cases, and through which we generally come to know who are the experts on what field. Secondly, the experts, regarding the experts' opinion, the Supreme Court has held that it is not that the expert opinion is binding upon the court, or you can rather say that the expert's opinion are of varied nature itself. In some cases, they are definitive. In some cases, they have less impact on the judgment. In some cases, they simply help court form the opinion. And in other cases, it sometimes kind of aid to the court information of the opinion regarding the case. Now, to understand this, we have to go through various cases of the Supreme Court. Like the first case that I shall discuss is between S.K.Belal Rahman vs State of Mysore. In this case, the court was to form an opinion regarding the purity of the gold. So the court asked a goldsmith to give its opinion on the matter. The goldsmith was just having experience and skill, on the basis of which he gave its opinion. In this case, the court took the opinion of this expert and held it relevant. So what we see is that the court is just looking at the skill and experience of the person while taking the opinion. But it is not so in every case. Like say in other case, as a case of between a state of Himachal Pradesh and Jailal. This case was regarding the impact of delay on the cost of construction. So in this case, the court held that it is not just the skill and experience, but it is also about the professional qualification of the expert that mattered. In this case, the court held that the professional qualification of the expert was also a prerequisite for taking the opinion. So you can say in the previous case of the goldsmith, the court just took the opinion of the expert who was expert because of his experience and skill. While in this case, the court is also wanting the expert to be having some professional professional qualifications. So the court has given varied kind of judgment in various fields, particularly on the basis of the kind of case that it has dealt. Now, coming to the other aspect of the judgment of the Supreme Court regarding the medical thing. About the medical expert, the court says that opinion of the medical expert and its evidentiary value are varied in different situations. Like the degree of the impact of various experts are varying depending upon the situation of the case. In a case between Maniram Vs State 1993 AIR, the court held that medical evidence is only an evidence of opinion and is hardly decisive. It is not substantive evidence. So the court is very forthright in its judgment in this case. It is taking the opinion of the expert, medical expert, as just an opinion and not decisive, hardly decisive. In another case, it is between Neelabati Behra versus State AIR 1993. It has held its opinion in a different way. It says here that the medical opinion of the forensic expert and the postmortem examination are reliable, and thus in this judgment the court has held the opinion of the expert on these issues like forensic and postmortem to be of the higher significance, of the higher degree correctness. Now in another case, it's a case between Madan Gopal and Naval Dubey in 1992 Supreme Court. The court again says again presents a different opinion. Like in this case, the court says that medical opinion, being an opinion, is advisory in nature, and it is not binding upon the court to form its opinion solely on the basis of this. It says that it has to take the data regarding the matter into the account and form its opinion on the basis of both medical opinion as well as the data which is available for the court to make judgment, to form opinion. Another very interesting case is a case between Prem and Daula. It's a case of AIR 1997 Supreme Court. In this case, there was a conflict between the opinion of an eyewitness and the opinion of the expert, medical expert. In this case, court held that it is the opinion of the eyewitness which will prevail over the opinion of the medical expert. Yes, you heard it right. The opinion of the eyewitness shall be preferred over the opinion of the medical expert. So regarding the ascertainment of the age in certain cases, court has also sought the opinion of the expert. This has been elaborated in the case between S.K.Belal Vs State 1994 Supreme Court. In this situation, there was a conflict to ascertain whether the girl was minor or not. According to the medical expert, the age of the girl was between 17 and 18. However, the document declared her age to be 18. In this case, the court held that the age written in the document shall be taken relevant, provided that the document is not forged. Now, two more things. One is the opinion of the DNA expert, another handwriting. About the DNA expert, the court has held that DNA expert science being absolute science, the opinion of the DNA expert shall be held reliable, relevant. Regarding the handwriting thing, the court says that the opinion of the expert of handwriting shall be taken as corroborating evidence, and it shall be only used as a corroborating evidence along with the circumstantial evidence. The court cannot form the opinion solely on the basis of the handwriting expert. So what we saw is that in these cases, the court has held different opinion in different cases depending upon the kind of cases that it had to dealt with, and on the basis of this, generally the precedents are set. So overall, you can say that the court, in this matter of expert, the court does not form the opinion on the blanket opinion of the expert, just on the basis of the expert, but it weighs the other evidences as well. This was section 45. Now the section 45A is talking about the opinion of the expert on electronic document. Here the court says that the professionally skilled qualified opinion of the profiled expert giving the opinion on the electronic record shall be held relevant. This is simple. So hope you are in a better position to understand what the court says about the opinion of the expert. Hope you enjoyed it. Thank you very much.